Good afternoon, everyone, and welcome to O'Keefe and Rhoades McKee's webinar, Practical and Legal Aspects of Restructuring Strategies in a Financial Crisis. During this afternoon's presentation, please feel free to submit questions to the presenters using the question panel on your screen. Our presenters will answer as many questions as they can, time permitting. Also, a copy of this presentation will be made available on O'Keefe and Rhoades McKee's websites this afternoon. With that housekeeping out of the way, I'd like to introduce myself, Pat O'Keefe, the founder and CEO of O'Keefe, a strategic and transactional financial advisory firm specializing in turnaround consulting, debt restructuring, and crisis management. I have served as Detroit's chapter president and as an international board member of the Turnaround Management Association, and also serve as chief executive officer of Grow Michigan, a MES fund supported by 16 Michigan banks and the Michigan Strategic Fund to assist growing businesses in Michigan. We are getting many questions from business owners who have practical concerns. We are hoping today to address some of those concerns. Every day, the business landscape is changing, and the financial markets have yet to stabilize, although much relief is being discussed and some already implemented. Today's topic, practical and legal aspects of restructuring strategies in a financial crisis. We have an experienced panel of experts from the consulting firm O'Keefe and the law firm of Rhoades McKee, who have worked through many crises. We thought it was important to address not only the legality of the financial decisions that business owners are considering, but the practicality of those decisions in a crisis environment. We have allocated 40 minutes this afternoon for discussion among the panel on key options, concerns, and possible courses of action. We have reserved 20 minutes at the end for your questions. It is most likely that we will not get to all of your questions and may have a need for a round two as new issues and courses of action arise. And it is not our intent to comment on each slide. There is no need to go through the background of how we got here, since it is well documented and we see it every day. So we will devote most of our time to our subject matter. But first, I would like to introduce today's panel, who have, some have claimed, have a face for webinars. Steve Weber is a director at O'Keefe. He works with manufacturing, service, and agricultural clients in the fields of turnaround management and restructuring, business refinancing, litigation support, and forensic and fraud evaluations, as well as performance and operational improvement. David Bevins is a partner with Rhoades McKee, specializing in representing businesses and financial institutions in and out of court, both by negotiating contracts and loan documents and providing solutions when problems arise. Mr. Bevins regularly appears in state, federal, and bankruptcy courts. Hal Nelson, also a partner with Rhoades McKee, his practice is in the area of business restructuring. Mr. Nelson works with business entities and stakeholders to solve financial problems. His clients include troubled companies and individuals, as well as creditors. So Steve Weber, I'd like you to tee up our discussion this afternoon with what everybody and every business has a concern over, which is cash.
Thanks, Pat. I'm going to address some of the issues regarding sources and uses of cash, particularly specific concerns regarding uses that businesses are likely to experience. Right now, it is critically important that businesses that are operating or perhaps are in standstill evaluate their cash inflows and outflows so they can make strong business decisions to be able to survive this downturn. There's many operational and legal facets that need to be addressed, and you need to consider, are you a critical vendor to someone, and who are your critical vendors? Regarding sources, some of the quickest sources of cash out there available to a business are, firstly, if you have an operational line of credit and can draw on that. Banks have been willing to potentially overextend or revise some of the terms on that, so that is probably your first source of cash in a business. Secondly, accounts receivable. Most businesses have accounts receivable from their customers, and there are potentially methods that you can use to have your customers pay early by offering discounts, etc. That's your second source of cash. Thirdly, if you have non-core assets in your business that are not necessary for your operations, you could potentially sell those to secure additional funding. On the uses, you need to evaluate who your critical vendors are. And you probably have a list in your mind of who you can't get along without, but you need to ask the question too is, are they operating? And if they're not operating, are there other sources? And can you continue to operate if they're not operating? And what are the source of funds, or what are the funds that you're going to have to remit to them? An important aspect throughout this process is develop a communication strategy. Communications with stakeholders in your business need to occur early, and they need to occur often because situations are going to change probably hour by hour and if not day by day as you go through this downturn. And finally, probably the most critical asset for your business right now are your employees, and you need to decide who is needed, who isn't needed, and how you're going to manage your workforce so that you have a labor force in place as you go forward. Critically, I would stress that businesses need to forecast, and revise that forecast as situations change as they go on. The next issue is, who do we need to pay? For practical considerations, we can divide them up into the employee category, which would include benefits to those employees and those critical vendors. You need to husband your cash resources strictly right now and delay where you can delay making payments to maintain your business in as liquid a state as you can. There may be deferral arrangements that are available for some of these that Pat's going to go into right now to preserve that cash in your business.
Thanks, Steve. So, the question always is for the business owners is, who can we really stretch out? And I thought I'd kind of run through some of the key bills that businesses have to pay and what some of the options may be. Landlords are often a big expense with rent, and today they have limited options to enforce their leases in terms of the courts being generally shut down. But what we've seen so far, and Dave Bevins will get into that in a second, on what some of those options that landlords have are, but what we've seen business owners do is communicating to landlords to ask for forbearance, put payments on the back end of leases, and request whatever relief is necessary. I think generally landlords understand that they would rather have a tenant in the building, and it's not like you can be easily replaced, since this is a pandemic that impacts all industries and all business owners. Utilities, many utilities have payment plans for business owners to the extent you can't pay. Again, I would be calling your local utilities and see what options you have to spread payments out. Generally, they have been fairly receptive in spreading bills out. Property taxes, again, a bill that we're going to see here in June and July, is a built-in mechanism to not pay. They often have provisions for delinquent payments. Of course, they have interest rates that are associated with that, but those taxes can be deferred. Bank, again, I think the thrust of the discussion today is going to be, you have to communicate a plan to a bank. And I'm going to get into it a little later as to what relief you can expect from a bank and what you can do. But generally, the banks today are considering overlines and principal deferments. Again, I think every borrower has to make their case as to why they need it and what the plan is. But again, there is that option, and I'm going to go through that in more detail later on in the presentation. Equipment leases. I'm going to share a quick story with you. We had a forging company about 8 years ago that the whole industry was imploding. They had a lot of leased equipment in their plant. And as a means of survival, we gave the lessors the option of picking up their equipment or giving us a 12-month lease deferral. And when faced with the option of potentially picking up equipment, selling it at an auction at a depressed price because nobody was buying, and then going against for a possible deficiency for a borrower that may be out of business, every lessor that we dealt with, and there were several of them, there were some fairly big financial institutions, agreed to give us the 12-month forbearance. And the company today is thriving and really made a nice turnaround in their operation. But again, they communicated quickly in that case with the lessors, gave them a plan, and they got the forbearance they needed. And then considering, change in your payment terms with your non-critical vendors, again, generally your vendors want a customer, they'll work with you. That 30-day terms probably doesn't work in this environment. Consider what you can do and communicate it. A lot of times with vendors, partial payments, or at least a strategy as to when you can start paying, the communication takes away a lot of the uncertainty and most likely adverse action that they're thinking about. I'd like to turn it over now to Dave Bevins to give us some idea as to what legal recourse the landlords have that don't get paid. David?
Thanks, Pat. As you mentioned, right now, landlords and tenants probably don't have a lot of short-term relief in terms of disputes. That's because the courts are more or less shut at this point. Complaints are adjourned. The Supreme Court has issued an administrative order that a complaint doesn't have to be filed, and when a complaint is filed, it doesn't necessarily need to be answered. Now, there's ways around that, but at this point in short term, the legal recourses are not great. In any dispute, I would look first to the contract, and I would look to force majeure provision. In addition, there are concepts like impossibility or frustration of purpose. The idea behind all of those is whether the parties have allocated the risk or whether this risk is unforeseeable. And we're going to get into these, I think, a little bit more later on. But the question right now is whether any of this is foreseeable. Sometimes, and in some industries, it may be. For example, let's say you have a purpose identified in your lease. If that purpose, let's say you're a restaurateur and you say, hey, my lease says I get to use this as a restaurant, and all of a sudden this happens and you can't use it for that. Well, that's a pretty clear example. But what if the purpose isn't in the lease? Then it becomes a little bit more fuzzy. So I would say if I'm a landlord, I'm not sitting back and thinking that I'm never going to get paid. I think you have some rights there. If I'm a tenant, I'm not sitting back and saying I'm free and easy, I don't have to worry about it. I think both sides have some risk here, and I would encourage everyone to communicate quickly and early, as Pat has mentioned.
Thank you, David. Our next topic is how to deal with employees. And Steve, do you have some thoughts on that?
Yeah, thanks, Pat. These comments are going to assume that a business is continuing operations at some level throughout this downturn. But right now, as I mentioned before, your labor force is probably your most important asset right now. And your asset is concerned about what's going on with the economy, what's going on with the business, and what's going on with their job. A few years ago, the Turnaround Management Association did a study of employees as to which they would prefer. Would they prefer a 20% reduction in force, firings at their employer, or would they prefer a 20% reduction in wages at their employer? And the strong choice was they would prefer a 20% reduction in wages and maintain their jobs even at a reduced payroll through a troubled time. So currently right now, I think employers, if they're able to do that, they should consider looking at part-time work or perhaps job sharing or maybe even a furlough. For furloughed employees, the most recent legislation that came out of Washington offers some security there through expanded unemployment benefits. And this is really a benefit to employers as well, because employees who file for unemployment insurance right now are not going to take a hit on their rating. And it's going to help keep their employees, in place and viable for when the economy turns back around in the future, which we all expect it to do. A key question that employers need to consider is, if they furlough employees, can they perhaps continue to pay benefits so the employees continue their health insurance? So there's lots of questions that, again, apply to the cash flow of a business that businesses need to consider. An important consideration for those businesses that are continuing to operate during this downturn is, what policies and procedures do they need to adhere to keep their employees safe and healthy? Are there additional cleaning requirements that they need to consider and put in place? And Rhoades McKee can certainly help you with these issues to make sure that you're complying for safety and liability purposes.
Steve, you made some good points there. And again, I think the big takeaway for our listening participants today is, employees generally would rather have the uncertainty of whether I have a job eliminated and take a reduction in pay than to be one of those that are on the permanent unemployment line. So again, I think as business owners, it's all about communication and how you deliver the message. But David, I'm curious, there's an executive order 2021 that kind of has some application here. And so I'm wondering if you could kind of educate us as to, what that executive order requires.
Sure. So first of all, the executive order identifies essentially two types of businesses and two types of workers that can remain working. One are critical infrastructure workers, and two are employees who are strictly necessary to conduct minimum basic operations. Couple of interesting aspects with that. Businesses have to make their own determination as to who is critical and who is necessary, strictly necessary. And while there's no really executive order police out there who are, the government's not looking necessarily to police this, our office has been in contact with some prosecutors who want guidance, and they are looking at whether they can go after and issue citations for violating these rules. So it's important for the businesses who are making this own determination to make it really in good faith. Another key aspect is that you're obligated now, as of today, to identify in writing who is critical, who is necessary, and the reasons behind that. Before today, you could do it verbally, but as of today, it's got to be in writing under the executive order. So while the executive order provides a list of who is critical and what a critical function is, you can all look at that on your own. What I think is interesting is that when you're working with employees, you only are allowed to keep those employees who are necessary for that critical function. So if you have a larger business, but only a portion of it is considered a critical aspect, you really have to focus and nuance your workforce down to that level. So in all of this, I think one of the key things that the employers need to think about is that if you're going to go forward and you're going to designate people and you're going to consider yourself a critical workforce, obviously you need to do it in good faith. And the executive order says that if you're mistaken, or if you're willfully mistaken, that you will be, quote, subject to the sanctions to the fullest extent of the law. And so that's a pretty big deal. And I think what you need to be considering in that respect is kind of what Steve mentioned a moment ago: the state and federal workplace safety rules, negligence claims. If an employee gets sick and you weren't a critical vendor, they weren't a critical aspect, you could be subjecting yourself to those claims. So Pat, I think that kind of covers a good breakdown of the executive order at this time.
Thank you, David. One of the big next two big issues we're going to deal with are dealing with vendors and customers. And Steve, do you have any helpful ideas here with the vendors?
Yeah, vendors are, I would say, intimately intertwined with who your customers are and what your customer needs are, but I'm going to focus on the vendors right now. You need to, again, as to what David mentioned about executive order compliance, make a determination of, are your vendors operating? Are they critical suppliers going forward, not just to you, but to the economy as a whole. Secondly, you need to evaluate what materials, if you're a manufacturer or supplies that you have on hand from your vendors to meet your customers' needs. Your vendors are going to have exactly the same concerns that you have. They're going to be very concerned that, number one, that they're going to get paid for what they're supplying. And you also need to consider logistically, are you going to be able to get needed supplies that you don't have on hand to you? Are there going to be trucks out there to ship it to you? So these are all issues that need to be evaluated with respect to what you need to supply to your customers. There are legal implications that I'm not going to go into, but I'll let David talk about whether or not a vendor is actually critical to you in your operations. If you should have a vendor that supplies a critical component to your product, which you're supplying to your customer, and they are shut down for whatever reason, you need to mitigate those damages and look for alternate sources of that same material that you can use in your product, and be sure to document those mitigation efforts as you go forward. David, do you want to talk some about the legal issues?
Well, before we jump into David, I think one of the questions, David, that has been on the tip of a lot of vendors is a real life situation where you have a product that is essential, but then your supplier is shut down. And, you know, Steve kind of walked through, you know, some of the essential and non-essentialness of some of those services. But, you know, what are your options to break a contract with a vendor who you determine can't perform because of lacking either financial resources or has lost their employment force? And then more importantly, because this gets into the legal aspect, is what do you have to do to document and support your action? If you could spend some time on that, it'd be appreciated.
Sure. So again, yeah, I think communication is the key. The first thing I would do, again, as I just mentioned, is under the executive order, you need to designate in writing that your vendor is a critical vendor, and I would identify that and why. The other thing that I would do under the Uniform Commercial Code is demand assurance. So if your supplier is either being wishy-washy or otherwise not being clear, and even if they are being clear, I would identify and demand assurance that they're going to supply and have them say no. And the reason that you want to do that is because you really want to set up for yourself that you're not, that you as the customer here are not breaking the contract, that they are the ones that are breaking the contract. So it's important to set up that concept right up front. And again, as we mentioned, you know, immediately the doors to the court may be closed. So if your vendor has tooling or design work, you know, that's going to be an issue that you need to deal with probably outside of the court at this point. If it's critical and you can show an emergency, I'm sure you can get some quick relief or relatively quick relief. But that's a real question at this time. And again, the other concepts that we're kind of dealing with here are force majeure, impossibility, and impracticability. And quickly, really what those ideas are getting at is whether the parties in a force majeure setting, whether the parties have allocated in their contract this risk of something happening. Impossibility is a concept that says, hey, there's something that happened here, we didn't foresee it, and now my performance is impossible. And frustration of purpose is very similar. These are all very similar, but talks about the purpose of the contract. Everybody knew about it, and now because of these things, the COVID-19, the executive order, we can't perform. So all of those ideas are going to be ideas that you need to deal with, and we're going to touch on those in a little bit depth in a minute. But these are all the concepts that are going to be very critical And I think communication, again, is going to be the key in setting up why you do and don't fit in, or why your customer or your vendor doesn't fit those circumstances. Pat, I think that's a good start to answering your question.
Thanks, David. So Steve, you know, as David pointed out, a lot of issues with vendors, but a lot of those vendors, you know, are customers to their supply group. And so what I'm wondering is, what are some of the issues now with the customers?
Well, they're, like you said, they're the same type of issues for a business with respect to their customers. Probably the two most important issues are, what are our production requirements for our customers, and what happens if we can't meet them? In terms of meeting our production requirements, this is where communication becomes key again. We may have a contract that indicates that we need to supply X quantity to our customer so they can supply their customers. And they may actually have no need for those parts right now whatsoever. And can the contract be modified to the new normal that's going on? Secondly, once we determine what it is that we need to supply, we need to go back again, as we talked about before, and look at our resources. Do we have the employees on hand and available to be able to operate and produce what we need for our customers? And do we have the materials, the raw materials, or perhaps sub-assemblies that go into our product to supply to our customers? And thirdly, we need to make sure that our customers are able to pay us. And if payment is slow, are there ways that we can incentivize them to perhaps pay us more quickly than they would? But planning on the front end, planning and communication with your customers and your suppliers is key, because the way operations occurred a month ago are not going to be the way things are going to operate right now. And there are certain contractual requirements that need to be adhered to in many cases. And if there's going to be a deviation from those, get documentation that your customers are accepting of that deviation, so that there's not an issue later on.
That's a good summary, Steve. You know, one of the issues that is often faced is people who are, you know, have OEMs as customers, and, you know, they have very punitive causes of action for supply chain disruption, which leads to their production stoppage. So say you have a customer, David, that wants delivery and you can't perform for a variety of reasons. You could have underlying suppliers that can't deliver to you. You've got employment force issues. What are your options to not incur contractual damages? What do you have to document and communicate?
Great question. And this is really just a flip side to the issue that I just discussed a moment ago. And again, I would say communication is the key. First of all, I would send out a demand for assurance under the Uniform Commercial Code of payment this time. I would say, hey, customer, you want me to produce here, but I don't know that you can pay. You need to show me that you can pay. If they can't make that showing, then I think your performance is likely excused. I think it's interesting when we talk about, and you know, then the next step would be to set up your force majeure, impossibility, or frustration of purpose defense. And what I think is important here, and maybe we'll dig in just a minute on this, is so if your customer is in a critical industry, then, you know, the question will become, there's two reasons you could argue that you're stopped from performance. One is the executive order from the government. The other is just the pandemic in general. And so looking at the executive order, is this a critical industry? If it's a critical industry, then maybe your excuse or your performance is not excused, because you're allowed to work under the executive order. You're allowed to perform. So again, when you're communicating back to your customer, you know, don't use that if you are a critical industry or if they are a critical industry. The law also is very clear that mere economic hardship is not sufficient to excuse your performance. So, for example, in 2008, when you know, our world was shutting down for a different reason, many courts have held that was not enough to generate an excuse to performance. Now, what about the pandemic itself? Is the pandemic itself an excuse? And, you know, the question is it foreseeable? And I think it seems logical to say that, that this kind of a response to this kind of a pandemic was not foreseeable. And yet I'm already seeing some arguments that, hey, you know, I mean, it's been a few years, 1918, I think it was, but it's been a few years, but pandemics are foreseeable. I mean, so it's not clear cut, and these are going to be interesting times, but those are the ways that I would start analyzing what my obligations are. And again, I think long-term thinking here is probably the best solution, with communication and talking to your customer about, hey, maybe entering into an agreement that provides them the documents and the tooling they need, but then a commitment back that they're going to come back and there's a longer term relationship here. So Pat, I think those are the main concepts I would try to cover.
Okay, that's a good synopsis to an area that's critically important in terms of understanding what your duties are, both coming and going in the supply chain. What I'd like to do now is talk a little bit about the options the banks have and the options that you have as a borrower. And the first aspect I want to talk about is defaults. And there's really, you know, three types of defaults that are out there. One is your covenant default, which usually is some financial metric that the bank has determined is important to monitor the status of your credit. So those are things like debt service coverage ratios or debt to equity ratios in terms of your performance within your operation. The second one is the simplest of all, and that's the payment default. You know, when you don't pay as prescribed in the loan documents, that also is a payment. There's usually not a lot of leeway with that. Sometimes there is a small grace period, but generally in terms of notice requirements, the view is the borrower knows when they haven't made a payment. And then you have your non-monetary defaults, and these are the ones that get tricky because they usually involve communication. So there are things like, you know, providing reporting on a timely basis, whether the bank needs your financial statements, tax returns, or whatever they are requesting from you in terms of the ability to monitor your operation. Could be projections for the year or whatnot. Those are usually in the control of the business, and but are often violated. And so you give the bank opportunities to look at some other things. And what you don't want is you don't want the bank necessarily picking winners and losers. And you know, it's not unusual for banks to exit industry segments. I mean, I can think over the last 10 years, we've seen banks exit, you know, the trucking area, agriculture, you know, construction, and you know, these are typically cyclical businesses, and the banks spend a lot of their time monitoring credit risk in these areas, and they will react quickly. And so a common clause that is in many loan documents relates to the material adverse change in the business. And that's a pretty global type decision that a bank could make. Now, this could be the result of a lost customer. It could be a death of an owner. It could be a whole host of things that are really in the bank's discretion as to what they view that material adverse change in your business is. The other issue that's practical for those that are on this call that fill out borrowing bases, I think it's a real situation that you're going to see the aging of your receivables move out longer and longer. As you know, receivables are typically eligible within 90 days of being invoiced. And again, I think with the cash shortage of people conserving cash, especially if you're a non-critical vendor, and even in some cases where you have cash shortages at your customers that are considered critical, your receivables are going to go past 90 days. And I think in those situations, you have to be able to demonstrate that the customer is going to pay. It's just not when he's going to pay is what is indeterminable. So again, I think showing the bank the payment history of some of your key accounts and being able to ask for that forbearance up front, not when you're out of formula and no longer have any borrowing capacity. To that end, early last week, the Federal Reserve, the FDIC, and several other bank regulatory bodies issued a statement to financial institutions that gave them some leeway in dealing with troubled debt restructurings. So modifications of loan terms don't necessarily result in a troubled debt restructuring, but typically they will when the bank is amending some of the financial aspects of your deal with them. The banks now, as a result of this pandemic, will have some latitude in dealing with some short-term loan modifications without being considered a troubled debt restructure. Why is that significant to the bank? Well, every time the bank has a troubled debt restructuring, they're typically having to book a loss in the form of a reserve against the collection of that particular account. And they don't like doing that. Nobody likes to report losses on credits. And so they try to minimize those losses. But this proclamation by these regulatory agencies gives the banks some leeway when you ask for payment deferrals, fee waivers, extensions of repayment terms, or other delays in payment, typically for a period of time to be something less than 6 months. And borrowers are considered current and eligible for this type of relief so that the bank doesn't have to book a troubled debt restructuring if they're less than 30 days past due on their contractual payments at the time a modification is implemented. So the significance of that, again, for the bankers is you've got to get out, if you're a borrower, and educate the bank on what it is you need and over what period of time, and do it while you're still current in the relationship. Don't wait till you're 2 months in default and then go to the bank hat in hand hoping they're going to be able to do something for you, because you've limited their ability to really help you. And again, most banks like to give 90-day forbearance periods of time if they are going to forbear in a situation. And again, I think this statement to the financial institutions from these regulatory bodies gives them some leeway to the extent you need more than 90 days. As we've seen these extensions for quarantine keep getting longer and longer, I think, I would, if I was a borrower, I'd be starting at 6 months and see what I could get from the bank. You probably end up with 3, but to the extent you've got a good relationship, you might get what you need. And my experience as a borrower is 90 days goes by in a blink of an eye, and you need financial runway to operate your business. But I think at this point in time, David, what are the bank's remedies in a default, where you can't make a deal? What can you expect?
Sure. A couple of just broad topics, and I think you hit on part of this, Pat. But if you're already a troubled borrower, the pandemic and what's going on is probably not a get out of jail free card for you. So I think Pat's instruction to you that if you're somewhat current right now, stay current and get on top of that is really good advice. I would also say that the loan documents are not in the borrower's favor, and that's frankly on purpose. It's set up that way because the bank does not see itself as an investor in a business; it sees itself as a lender, and so just keep that in mind when you're dealing with banks in all of these circumstances. Now, I would echo what Pat said: communicate. The quickest I've seen banks jump into litigation is when the communication stops. So you really want to avoid that. Now, assuming there's defaults that have been triggered, the banks have some really important remedies. A couple of these remedies are available to the bank without having to go to court. So you need to be aware of those. First, if you've pledged all of your assets, including accounts receivable, the bank is permitted under the Uniform Commercial Code to simply send a letter to your creditors or to those who owe you money, and just start collecting directly from there. And once that letter is sent, those parties that owe you money cannot discharge their payment obligation by paying you. They have to pay the bank. So that's an important one. Another important, non-judicial remedy is if you have your account with your bank, your cash accounts, the bank can set those off for the most part without a court order. So those are two really important remedies that you need to be aware of if you're already in default. That can happen without going to court. Obviously, the courts get involved when the bank wants to reclaim all of your property. Again, if you've pledged your assets, they can go to the court and get an order for turnover. There's judicial foreclosure of real property. The bank can, and that process takes about a year. The bank can go through a foreclosure by advertisement on real property, and that's about a 7 or 8 month process. And these days, if you've pledged your commercial property and your business assets, the bank can get a receiver over all of your personal property and real property and have that receiver essentially run your business, either to piece it out to sell it or to sell it as a going concern. With respect to guarantors, a lot of companies have their owners as personal guarantors. That's a separate right for the bank. So the bank doesn't have to proceed against the assets or the company before it looks to its guarantors. Those are completely separate rights. And I've been involved in many circumstances where the guarantor is relatively well heeled, and the bank will look there first before it has to go through all the other work. So finally, even if you haven't guaranteed the debt, you should be aware as a business owner or somebody interacting with the bank that there can be some personal liability that flows through. And one of the areas where this can happen sometimes is, I think Pat mentioned borrowing-based certificates. If you're misstating those, that could be a fraud, and you are then liable for your own fraudulent activity as somebody who made that statement. So there can be some personal liability that flows through there. And finally, I would say, if you've received a default notice from the bank and a demand to turn over assets, there may be an argument that you're holding those assets as a fiduciary for the bank at that point. That's a little bit longer of a road to hoe, but that is another way that personal liability can attach. Pat, I think that covers the landscape for now.
David, that's a good synopsis of what the bank's options are. And I suppose, when all else fails and you can't make a deal, borrowers often look to the bankruptcy options. And so I'm going to ask our cleanup hitter, Hal Nelson, here to talk about what the borrower's bankruptcy options are.
Thank you, Pat. When the other courses of action that have been discussed by Pat, Steve, and David prove unfruitful, the businesses typically will look at bankruptcy. And I'm going to touch on several bankruptcy issues in a fairly summary fashion. First of all, what advantages are offered to businesses seeking bankruptcy? Well, first of all, it will stop all collection activities, evictions, repossessions, and all pending litigation through use of the automatic stay. It allows a company to reject unprofitable or otherwise burdensome contracts, and that includes leases. It provides essentially a breathing period for the business to determine what it is in a position to do and to negotiate the terms of a plan of reorganization with its creditors. And in some circumstances, it serves as a venue for an orderly sale of the business. Now, I'm focusing here on reorganizational bankruptcies, which are under Chapter 11 of the Bankruptcy Code. There are really two types of Chapter 11s now. There's the traditional Chapter 11, which has been with us for a long, long time. And in February of this year, there was a revised small business Chapter 11 case. And I'm going to talk about that because that's kind of the new kid on the block. The key differences between a small business Chapter 11 and traditional Chapter 11 is there's a debt limit which defines a small business. And that small business has to have less than $7.5 million in unsecured debt, or secured and unsecured debt. That debt limit was more than doubled under the CARE Act that was just recently enacted. The Small Business Chapter 11 is essentially on what we call a rocket docket. There's a 60-day period to file a plan of reorganization. And if everything goes smoothly, a company could enter and exit its bankruptcy case in 6 months or less. Another difference between Small Business Chapter 11 and the traditional is there's no creditors committee in the Small Business Chapter 11. Creditors committee is certainly an added expense in a bankruptcy case, and sometimes creditors committee can be kind of a pain in the butt. So that's an advantage to a Small Business Chapter 11. Also, the absolute priority rule does not apply in a Small Business Chapter 11. Simply put, the absolute priority rule means that if there is a dissenting class of unsecured creditors, the equity class, that being the shareholders, can receive nothing unless the dissenting higher class is paid in full. That can be a real problem in the traditional Chapter 11. That problem doesn't exist in the Small Business Chapter 11. Essentially, the Small Business Chapter 11 was designed to be cheaper and faster than the traditional Chapter 11. Now, there are certain problems that arise in both types of Chapter 11s. The biggest problem is often access to cash collateral. And cash collateral is when the secured creditor, I'll call them banks at this point, have a lien on all pre-petition inventory, accounts receivable, and oftentimes security interest in your bank account. You're required to provide adequate protection, which means no diminution of the value of the bank's collateral, to be able to use any excess to run the business. Determining what cash collateral you're allowed to use is usually a matter of negotiation between the company and the bank to determine what the bank will accept as adequate protection. And you know, in this COVID environment, banks may adopt a more liberal approach as to what is adequate protection than they might otherwise, at least if the company is a good bank customer and, as has been said, communicates with the bank. Another issue is landlord obligations. Generally have to pay and perform your leases in accordance with their terms. And so that's a cash need that hits you early on. Utilities have the right to demand deposits, and that's a cash need that hits very early in the case. And then, of course, there's professional retainers for your attorneys, turnaround consultants, accountants, and the like. And finally, your vendors, or many of your vendors, will typically demand payment COD when you file bankruptcy. So those are a lot of front-end cash needs. And what if the company is not deemed to be critical or essential and is shut down? Typically would have no revenue and little, if any, non-encumbered cash. At that point, it would have to, again, negotiate hopefully a very liberal cash collateral relief with the bank. maybe get an equity infusion from the existing owners or other sources, provide some attractive guarantors, maybe collateralized guarantees. And also there's possibility, and I'm not sure if this is an attractive possibility, but it's to rely on the government relief borrowing that's part of the CARE Act. The problem with that is it's still kind of up in the air when that money will be available and what amounts. There's going to be thousands, literally, of companies seeking that relief. And the timing of receiving that money is a big issue and may make it difficult in a Chapter 11. Pat, that's my overview of the bankruptcy options.
Thank you, Hal. Again, I think, for those that are on this webinar, the key takeaway here is that, bankruptcy will stay adverse action, and you can relieve yourself of burdensome contracts, including, lease agreements. But the two key things, I think, if you go down this path that you have to be aware of, that Hal covered in his talk, is that you need cash. I mean, everybody thinks you go into bankruptcy and all of a sudden you continue to operate. That's not true. You will need cash to operate within the bankruptcy. And more importantly, you need to have an end game as to what you want to do. You don't want to file and then just flounder through it. And as Hal started with, there is a fast track program for borrowers who have less than $7.5 million worth of debt. And that is something that is valuable for those who need that type of relief. I want to switch gears now and open it up for questions. We've got a lot of questions this afternoon, and we're going to cover some of them. But one of them that has been pretty consistent is dealing with, Steve, some of the SBA options and how quick you're going to get the money, and how the Paycheck Protection Program works, and what kind of relief do you think is available from banks? And maybe you could spend a minute and just talking about some of the things that you're seeing out there, and offer some thoughtful comments on that issue.
Sure. Pat, as you mentioned, communications with your bank, if you're seeking relief currently from your current bank, need to occur while you're still in good standing and current with them. There are payment deferrals. Perhaps you could switch loans to interest only. You might be able to relax some of your loan covenant provisions, specifically things about accounts receivable over 90 days falling out of your borrowing base. That is probably one of the first things that you should take a look at. Another, under the CARE Act, there are a number of programs there that are in existence. Applications are already online. If somebody would like a reference to those applications for the payroll protection program, I can send that off to them. But a lot of the early discussion was that it was a completely forgivable loan, and it's not. It can forgive about 2 months worth of payroll costs, but it offers a potential borrower a very low rate. There is that portion of forgiveness there, and this really could be a way to kind of bridge this slow time with some loan money to allow you to continue to maintain your business in a viable position so you can operate going forward. There are a number of other provisions in the CARE Act that are going to be beneficial to business going forward, but it's going to take time for the positive economic effects to come through, such as removal of limitations on net operating losses. Those will be fully applicable. You can carry those back 5 years instead of the previous limit. There's some removal of some limits of offsetting losses on pass-through entities against ordinary income that's going to help reduce tax bills. There's also some significant dollars in the CARE bill for the agricultural industry. $14 billion is going to the Commercial Credit Corp. Just to kind of visualize that amount, Over the past couple of years, there was the market facilitation program designed to assist farmers during the export downturn due to the trade war with China. This is as much as the prior year of those market facilitation payments. There's an additional $9.5 billion out there for specialty ag products, including fruits and vegetable producers, as well as, animal producers, dairy producers. I don't have any specifics yet on how ag producers apply under either of these two programs because they haven't been issued yet. But as soon as I learn something, I'll certainly be posting on our website.
Thank you, Steve. David, we've got a lot of questions on, force majeure and contracts, and I'm going to just throw out a bunch of these questions, and then you pick one here that you want to get into.
Sure.
Somebody asked, what kind of things do I have to document to claim force majeure, either under my contract or under the UCC? I've been making a product for my customer. Half of them are built, and I just received notice from my customer that he cannot take my product. What should I do? So, any thoughts for, some of these issues?
Yeah, again, I think the question it poses the right, the intent here is everybody's in the right frame of mind. You need to look at communication, and either way, you need to set it up. So the communication piece really, I think, begins with, from both sides, demanding assurances. So if it's your customer, say, hey, you say you want this product, I want you to show me that you can pay for it. Because if you can't show that, then I'm not going to produce it for you. In terms of force majeure and impossibility, again, I think it gets back to documenting the reasons why. For example, if you're being asked to perform and you can't, then you need to identify why you can't. You need to say, the executive order 2020-21 applies to me and I'm shut down. I may not work. Or you could say, the pandemic has thrown us off. It's not just the economics, but my employees just won't come in. It's those kinds of factual things that you need to communicate in order to show the other side that you're not just not performing, but that it is impossible, or that it is within the force majeure language of your contract.
So, David, there's another question here that I think deals with the executive order, and I want to just throw it out there. This particular business appears to be a non-essential service, but they have the ability to still stay operational and work remotely, except one key employee can't work remotely. And the question is because they can't work remotely, can they work in the office? And I think, the issue here is, essential versus non-essential, and I'm not sure that convenience enters into it, but maybe you have some thoughts on it.
Yeah, I think, again, what I would do in that circumstance is I would communicate to that employee, designate that employee as essential, and identify reasons why their presence in the office is essential. For example, in our office, we have mail coming in. We have other kind of practical things that if you're not sitting there, can't be done. So we have even what I would consider to be, not our top level employees, maybe a little bit lower level employee, coming into the office to deal with those kinds of issues. But again, identifying it under the executive order and communicating that under the executive order, I think are important things to do.
So would you say that if you're not an essential service, you could still have employees work even though they can't work remotely?
Yeah, so the executive order, even if you're not critical, even if you're critical infrastructure, the executive order allows employees to do work on site that are minimally necessary to keep the operations going.
That is a great distinction. We've got several questions on that issue, and there was a question raised about the notification or letter for critical workers to work and what it has to include. I'm going to defer the writer of that question to contact you directly, because we do have contact information on the back, and maybe you got an example or something that you want to cover. But you know, there hasn't, as you mentioned before, not been a lot of enforcement relative to, you know, who's critical and who's not. I know, you know, we post a letter on our front door in case anybody questions it. We are viewed to be an essential service because we handle financial services and have lots of requests from critical companies that are producing things that are viewed to be essential and need financing. But you know, I would say if you've got a question on that, I would point you to Rhoades McKee. We do have contact information for any follow-up questions, and I think there'd be some great insight to that. Well, we're at 1 o'clock, so I'm going to wrap it up. Again, I think the questions that we had today were good from our participants. We tried to cover as many as we could. I have to say this was a very inquisitive group, because there were several. I tried to condense some of those questions. But we have included some websites for financial assistance at the back of our presentation. The slide deck will be, as I mentioned earlier, posted on both the O'Keefe and the Rhoades McKee websites, so you'll have access to that. And a lot of these, if you just click on to them, they will point you in the right direction for loan applications and additional information. And in closing, as business owners, you know, now is really the time to make some tough decisions. This is clearly an unusual circumstances, and we have employees, families, and stakeholders as business owners that depend on our stewardship and leadership. I'm reminded, you know, from time to time of the late U of M athletic director Don Canham, who once said that success is 90% planning and 10% execution. And now's the time to be doing some forward thinking and planning on how you need to keep your business afloat for the next 120 days. And the resources at O'Keefe and Rhoades McKee are available to help you during this time. Our contact information is included in the slide deck. And I want to thank you all for attending our webinar, and thanks to our panel for presenting. Have a good day and stay safe. Thank you.